In this video, we'll discuss question number 6, and that is discuss this statement that the foundation of the doctrine of election is that no one can appropriate and reprobate at the same time, as it is provided under section 35 of the Transfer of Property Act 1882. So, the very doctrine of election is an obligation to choose between two inconsistent or alternative rights in a case where there is a clear intention of the grantor that the grantee should not enjoy both. The foundation of the doctrine of election is that the person taking a benefit under an instrument must also bear the burden. In other words, a person cannot take under and against one and the same instrument. Suppose A by A deed gives to B a house belonging to himself to C, and by the same instrument gives other property belonging to himself to C, conforming to all the provisions of the instrument by renouncing the right to his own property given in favor of B. He must consequently make his choice, or as it is technically termed, he is put to his election to take either under or against the instrument. If she elects to take under the instrument, he must relinquish in favor of B his property given to B by A and take the property which is given to him by A. So the first paragraph of section 35 of Transfer of Property Act 1882 embodies the doctrine of election in the following language: that where a person professes to transfer property which he has no right to transfer, and as part of his same transaction confers any benefit on the owner of the property, such owner must elect either to confirm such transfer or to dissent from it, and in the latter case he shall relinquish the benefit so conferred. The doctrine of election is defined and explained by Professor Maitland as it is he who accepts a benefit under a deed or will must adopt the whole content of that instrument and conform to all its provisions and renounce all rights that are inconsistent with it. And in that connection, we'll discuss an English leading case, and that is White and Tudens, where it was pronounced election is the obligation imposed upon a party by court of equity to choose between two inconsistent or alternative rights or claims in cases where there is clear intention of the person from whom he derives one, that he should not enjoy both, that he who accepts a benefit under a deed or will must adopt the whole contents of that instrument. So, in Indian context, we will discuss one important leading case decided by Supreme Court, that is Bhav Ram versus Bajnath Singh in 1961, where it was applied the very doctrine of election by the Supreme Court. And regarding the very analysis of this section, as we found, the transferor must profess to transfer, must confer on the owner, and transfer and confirming the benefit must be directly conferred and conferred on him in the same capacity. And to explain it, as the transferor must profess to transfer a property which he has no right to transfer. It is immaterial whether in doing so he knows or does not know it to be not his property. And the second analysis of this provision is he must confer on the owner whose property he parts to transfer to another person. And the third analysis, we found the two things. For example, the transfer and conferring of the benefit must form parts of the same transaction. And the fourth point of analysis that we found, the benefit must be directly conferred upon the owner of the property. And the fifth point that we found from the analysis of this section 35, that is, the benefit must be conferred on him in the same capacity in which he is the owner of the property. And now we will discuss certain effects of election against the transfer. So, where the owner descends from the transfer of property, he must relinquish the benefit, and the benefit would then revert to the transferor. So, the very descent of the owner from the transfer of his property, the effect follows he must relinquish the benefit. Second effect, the benefit intended to him would then revert to the transferor. And in relation to that, we'll discuss one example, and that is A makes a gift to C of a property belonging to B, and by the same date gifts are as 5,000 to B. If B does not agree to the transfer of his property to C, he cannot claim as 5,000 which reverts to A. So, this would be the best example in regards to doctrine of election, which is the foundation, is that no one can appropriate and reprobate at the same time. So, where the transfer is gratuitous and the transferor has before the election died or otherwise becomes incapable of making a phrase transfer. For example, the disappointed transferee has a claim for compensation. In this respect, the English law is different because than the donee electing against the instrument does not incur a forfeiture of the benefit conferred on him by it, but is merely bound to make compensation out of it to this person disappointed by this election, where the donee suffers from disability by reason of infancy, lunacy, and so forth, the election shall be postponed until the disability ceases or until the election is made by some competent authority. So, in regards to the very answer to this question, we found certain important leading cases, and that exactly we want to make reference of these important leading cases while answering this particular question relating to the very doctrine of election. So, the first one, that is Messrs. Transcore versus Union of India, and it was decided by our Supreme Court in 2006, and the second important leading case relating to Section 35 of the Transfer of Property Act in relation to doctrine of election is India Bulls Housing Finance Limited versus Messrs. Deccan Chronicle Holding Limited, and it is also a case of 2018 decided by the Supreme Court. And the third important leading case that one can cite while answering this question is Irogress Realtech Private Limited versus Abhishek Khanna, and it is a leading case of 2021 decided by Supreme Court while interpreting the very doctrine of election as the foundation where no one can appropriate and reprobate at the same time. And the last important leading is that one can cite while answering this question is Navdeep Kumar versus State of Punjab, which was decided in 2023 by the Punjab and Haryana High Court while applying the very provision of Section 35 of Transfer of Property Act 1882. So, while answering the very question regarding the foundation of the doctrine of election is that no one can appropriate and reprobate at the same time, we just found the very explanation and how it was explained by Professor Maitland, and who clearly defined it that he who accepts a benefit under a deed or will must adopt the whole content of that instrument, which conform to all its provisions and renounce all rights that are inconsistent with it. So also we discussed one important leading case, and that was an English leading case, White and Tandon's case on equity, and in case of an Indian important case that we have discussed, Bhauram versus Bajnath Singh, which was decided by the Apex Court in 1961. So also we have made the analysis of these sections, and we found almost 5 points that we found after analyzing this section, and we also deal with the effect of election against the transfer. So also an important example and all those important leading cases that one can cite while answering this question, then it would be the correct, exact, and appropriate answer to this question, the question number 6, and which asks discuss the statement that foundation of the doctrine of election is that no one can appropriate and reprobate at the same time. So, in our upcoming video, we'll discuss question number 7, and that is the accessory follows the principle. How far the maxim is applicable to transfer of property. So, this very provision regarding the answer to this particular question we found under section 18, which provides general presumption as to transfer of property.